We'll now recognize the ranking member, Mr. Green, for 5 minutes.
Thank you, Mr. Chairman. Let's start with the first option available, which is bankruptcy. Bankruptcy is not precluded by Dodd-Frank, and I think all of our scholars will agree that bankruptcy is still available. But for fear that I may be mistaken, if you agree that bankruptcy is still available, would you kindly extend a hand into the air? This is sort of like voir dire. Okay, thank you. All right, let the record reflect that all members of the panel have indicated that bankruptcy is still available. In fact, there has to be a determination of the entity, the company, the large company, I might add. It has to be a determination that it's either in default or in danger of default. Is that a fair statement, Mr. Merritt?
That's an accurate statement, yes.
Okay. Default or in danger of default. There also has to be, before we get to that determination, involvement of the FDIC, the Federal Reserve, and then you have to confer with the President of the United States. So we're talking about a time of exigent circumstances when we have perhaps what we had in '08, when banks would not lend to each other, when you could not have other businesses that could go through the bankruptcy process, go to the bankruptcy process, and assist a business that was, in fact, in bankruptcy. We do have these extreme circumstances where bankruptcy does not prove to be an option. Only after we have justified that there's an extreme circumstance do we then go to OLA. Mr. Merritt, do you agree with that, that there is this justification process? Now, I know your point is that it's all a part of the executive, and I'll get to that in just a moment, but that's your point, right?
That's right, and
okay.
I don't necessarily disagree with your characterization of
okay, let me continue. So once we do get to the district court, we have Rule 85 to contend with. Now, for those who are concerned about secrecy, Rule 85 indicates that if the petition of the Treasury Secretary is granted, then the Secretary has to show cause why the veil of secrecy should not be lifted. Do you agree that Rule 85 does this?
I'm familiar with the rule. Perhaps the other panelists are not, but that is correct.
So Rule 85, which applies to the district court that the case must be filed in, this is the court that of venue and of jurisdiction, so you have to go to this court. This local rule has already been promulgated to address the very question of secrecy that has been raised. Next point. Before I get to you, Mr. Gray, we'll try to get to you in just a moment, but there's one other thing that I have to do. The ruling of the district court is not the final word. In fact, you can appeal from the district court to the next level, which would be the appeals court, circuit court, and you can appeal from there to the Supreme Court. So the district court ruling is not the final word. This can go all the way to the Supreme Court of the United States of America. And the Supreme Court has supreme authority. Supreme Courts make rulings that we don't always like, but hopefully we'll continue to respect them. Now, with reference to the process itself of appeal and of filing the petition, do you agree that in major questions of any time, you have constitutional scholars on both sides of the issue? It is not unusual to have constitutional scholars on both sides of an issue. We just had several cases before the Supreme Court recently. Constitutional scholars on both sides of the issue. Do you agree, Mr. Merritt, that you have constitutional scholars on both sides of issues?
On many issues you do. I'm not sure that there are going to be two constitutional scholars on either side of the question of whether there's no hearing or opportunity.
Well, we already have. You do not consider your friend sitting next to you a scholar? Is that what you're saying? Well, I'll let you decide who's a constitutional scholar or not. Let us just say for our purposes that we have people who hold themselves out as experts who will testify on both sides of this issue. That will happen. It's happening right now. And until a court rules, we don't have an issue that has been declared unconstitutional. We don't have any aspect of this law that's been declared unconstitutional. So I appreciate your taking it to court. those of you who are litigating, I have no quarrel with your taking it to court. I will respect the decision of the courts, but I do think that we can't conclude now that it's unconstitutional. What we have are opinions. I'll yield back, Mr. Chairman.